Hi, I'm Texas attorney Dan Lazarine. Let's talk a little bit this morning about a different topic, mistrials. What exactly is a mistrial? When does it come about? And what happens after a judge declares a mistrial here in Texas? Generally speaking, a mistrial occurs when a jury trial doesn't end in a satisfactory manner. So most jury trials end in a unanimous guilty verdict or a unanimous not guilty verdict. However, sometimes it's just not possible to reach one of those conclusions. The most common example of when that happens is when a jury cannot unanimously agree on a verdict. So sometimes that's referred to as the jury being deadlocked. Usually in a jury trial, a jury will send notes to a judge saying they're deadlocked. Maybe they're hopelessly deadlocked, and if the judge wishes to do so, he can order further deliberations. But what we're discussing is a situation where the jury simply cannot reach a decision, and eventually the judge is forced to end the trial, and he does that by declaring a mistrial. So what happens to a criminal case after a judge declares a mistrial? Is the case over? Is the charge dismissed? Is the defendant free to go? No. The case is not dismissed automatically, and it doesn't end. In fact, what happens is the case goes on. So one of three things normally happens. One, the prosecutor decides to dismiss the case. Maybe they think they gave it their best shot. Something came out in the trial that changed their assessment. They dismiss the case. Another possibility is a plea bargain is reached between the defense and the state. Maybe it's a little bit better for the defendant than what was offered before trial. A lot of times this happens, the case is resolved by agreement. Or the case is set for a new trial. They're given a new trial date, and both sides march forward for another jury trial. If that happens, it's very important for a defense lawyer to get copies of the transcripts from all the state's witnesses' testimony. That way, if any witness changes their story or something else comes about, that testimony, which was given under oath, can be used. Is there ever a situation, I'm asked this often, is there ever a situation where the prosecutor, by law, cannot continue, or the judge won't let a prosecutor retry a case? And there is a situation where a prosecutor can't retry the case. It requires a lot of steps, but basically it's a situation where the defense was goaded into moving for a mistrial. Due to some sort of misconduct on part of the state, the defense had no choice but to ask for a mistrial, and later, which was declared by the judge. If a judge finds, subsequent to that mistrial, that the defense had no choice because of that state misconduct, then the state might be barred from retrial of that case. If you have any questions about this or anything else you're dealing with, give us a call or visit our website. We'll talk to you soon.